submits that privilege is not appropriate in this case, and we can see that it is not appropriate. Under Rule 73, the mechanism for recognizing new privileges would not be met in this case. And even the privilege for war correspondence in the prosecutor versus Virjanin case of the ICTY, she would not meet that two-pronged test.
Thank you. Thank you. Don't believe by that point.
Yes, Your Honor.
I was going to say to you that should the ICC concern itself with Miranda's rights, like we call them human rights, she was detained, brought to court? Do you think the ICC should concern itself with that? Because once she's in the seat of the court, she's a terrible witness. You want us to take into account that she was illegally arrested?
Yes, Your Honor. We believe that the court should be concerned with this issue because this court is the reason why this investigation is taking place. Without the request for cooperation under Article 93 made by the prosecution, Miranda Phoenix would not be looking to detain and surrender Miranda Phoenix at this time. It is only because the prosecution has asked for such cooperation, and therefore the court should be very concerned in how Miranda Phoenix is treated due to its requests.
Is that a question of the law? Like the court should concern itself with what happened before
Yes, Your Honor, the defense believes so because the entire reason why Miranda Phoenix is being surrendered to the International Criminal Court is because of the actions of the court itself. So the court should look to protect people involved in these investigations. In regards to the last point, the applications of victims K1 through 34, Rule 85 requires two things. First, that the victims prove that they suffered actual harm. And second, that they demonstrate that there is a causal link between the harm that they claim and the conduct of President Turk in this case. We believe that the court is rightly concerned that there is no objective measure of emotional harm and mental harm in this case, as opposed to the other decisions where emotional and mental harm has been recognized. Objective observers could see that those victims were coming from environments of unimaginable violence, seeing sometimes the rape and execution of family members right before their eyes. In situations like this, there is no question that there is emotional trauma. However, here, Your Honors, victims K1 through 34 claim emotional harm on the fear of a nuclear attack. But where is the causal link to President Turk's conduct? There is no mention of nuclear weapons in the newspaper article written by Miranda Phoenix. There is no mention of nuclear weapons in his subsequent speeches that he made within Pemba. The mere fact that the victims allege this should not be enough for them to gain victim status. The court should require that they show some form of objective evidence that they have suffered harm, perhaps in the form of psychological evaluations. And once that they can show this objective evidence, then they can be granted victim status. We must remember that under Rule 89, even if the victim's application is rejected at this time, they may reapply for victim status later in the proceedings. And under Rule 91, the trial chamber will be able to reverse any decision made by this pretrial chamber regarding victim participation. This is not the victim's last chance to apply. Once they have some objective measure that they have suffered harm, the defense has no problem with those applications being granted. But at this juncture, they have not met their burden of proof, albeit a very low burden.
And how does this situation compare with to other incomplete crimes, for instance, that in terms of the harms?
In comparison with other inchoate crimes,
say an attempted burglary where your law is broken, but nothing is good.
I mean, I think I see where you're going, Your Honor.
You risk contempt.
I believe that the two situations that we're comparing here are very distinguishable, as there has been an actual physical act when the locker of your door in your home has been broken fear that someone has actually been there. The victims here are claiming complete psychological fear. And we believe that the cause of their fear, if their fear exists, is not the speech of President Turk. It's much more likely that it is the fact that diplomatic relations have not existed between these two countries for a period of 10 years, that there is violent rhetoric coming between the politicians on both sides, and thirdly, Tuva, a nuclear power in its own right, is now fearful because EMBA is starting to build a nuclear defense capability. It's perfectly within the rights of the state of Tuva to build up their defense capability, especially seeing.
Yes. Just to let you know that there is case law at the ICC for the accused James and my brother will be delighted to make them available at a convenient point. To the effect that which has considered that material, physical, and psychological harm are all forms of harm that fall within the rule if they are suffered personally by a victim. So we will be happy to make that case law available.
Yes, Your Honor.
Counsel, before the conclude, I want to take you back to the person's your jurisdiction. You very briefly express us as to whether, in your view, incitement to commit genocide was actually committed by the, could be concluded from the interview that the incitement to genocide was actually committed.
Whether reasonable grounds would exist?
No.
Oh, or whether the crime could take place, whether it had been committed through the interview.
From the interview of President Taft, that from there could you conclude that incitement to genocide was committed?
No, Your Honor. We believe in this case that is not a conclusion that can be drawn.
So why?
The cases that have prosecuted incitement to genocide through the past, especially using media, there's one distinguishing characteristic. We can look to the Nuremberg trials of Julius Streicher, or we may look to the media case of the ICTR. When media was used in that case, the people committing incitement and that were convicted of incitement had direct or indirect control over the media in that case. They controlled what the media was putting on. Here, we have a third party, a neutral party, part of the free press. They had complete control over the printing of the interview. They had complete control over the dissemination of the interview. And therefore, the nexus between President Turk and how the interview is actually used to incite genocide is much different. As in Rwanda, we know that it was used as a tool by the Hutus to encourage incitement. They would not allow any other kinds of media to be played. It was the only thing the public was hearing, and it seemed like a legitimate news media. Here as well, we had one newspaper in a world filled with free print media, free online media. There are many opposing opinions, and we believe, especially, that it can be reasonably assumed that within the state of Tuva itself and the international community, after such controversy and upheaval came about with President Turk's article, that many opposing opinions were put forth, and many articles reflecting their views were put forth. And one last thing that the defense would like to submit. Even if these are President Turk's statements, however despicable they may be, hate speech is not criminalized under international customary law. And there is a line to be drawn over what is considered incitement and what is considered hate speech. And the defense submits that that line is that there actually be a reasonable possibility that President Turk's statements could actually cause genocide. And here we believe the possibility does not exist.
Thank you. Conclude.
Yes, Your Honor. That concludes the defense's submissions. We ask for four things. First, this court not exercise jurisdiction over this case. That this court grant President Turk conditional release due to the Article 98 violation. Third, that this court cannot compel Miranda Phoenix to appear before this council, before this chamber. And fourth, that victims K1 through 34 must present some kind of objective evidence of their harm before granting